Here is a question that quietly decides who actually runs a country. Imagine a president who could spend any amount of public money and borrow billions in the nation's name without asking anyone at all. Would it really matter that there are elections, courts, and a constitution on the books? It would not, because whoever controls the money controls everything else that power can do. That single insight is the power of the purse, and the entire field of public finance law exists to prize that power out of one pair of hands. This is the full, exam-depth lecture on it, and we are going to go slowly and cover everything. By the end you will understand the idea in your bones. You'll know the precise articles and rules the examiner expects: Article 125, Article 126 subsection 2, Article 127 subsection 2, Rule 69, the Mozambique hidden debt case, and you'll know exactly how to convert it all into a distinction-level answer. We build it brick by brick. Let's begin. Strip away the accounting language and public finance law rests on one stubbornly simple lever: money. Whoever controls the public money controls real power, the power to reward friends, starve enemies, build armies, fund schools, win elections. So the central move of any serious constitution is to refuse to put that lever in a single person's hand. In Namibia the money power is deliberately split: the executive proposes and the executive spends, but Parliament, the elected house, the people's house, must authorize it first. Hold that distinction tight, because everything today is an elaboration of it. The president does not own the purse, Parliament holds the strings. That shift, from the will of a ruler to the authorization of the people's representatives, is the entire game. Let me make this concrete with the first of two analogies: a credit card. Handing someone your credit card is really handing them a slice of your power. Now imagine the card has no limit and nobody ever looks at the statement. The person holding it effectively controls the whole household, regardless of who technically earns the money. They can swipe at will, on anything, and no one can question it. That is exactly the situation a constitution must prevent. So what do sensible people do? Two things. They set a limit, that's approval before the spending. And they read the statement at month end, that's the audit after. With those two controls in place, the cardholder still does the spending, but only within bounds the others set, and only on things the others can later inspect. Hold that image: the unchecked card is unchecked power, and the limit plus statement is the whole of public finance law in miniature. The second analogy deepens the first. Picture the household itself. One person earns most of the income, but the family has long agreed that any big purchase, and especially any new debt, needs everyone's approval first. The earner cannot quietly remortgage the house to fund a project nobody else has signed off on. That's the approval before half. And just as importantly, someone other than the person doing the spending sits down each month and checks the bank statement, line by line, to confirm the money actually went where it was meant to. That's the check after half. Now map it onto the state, and keep this map for the whole lecture. The earner who spends is the executive, the family meeting that must approve is Parliament, the person quietly checking the statement is the auditor. The entire constitutional machinery we are about to study is just this household, scaled up to a nation: approval before, honest check after. Now two technical words that carry the whole idea: revenue and appropriation. Revenue is the money coming in, taxes, levies, duties, state income of every kind. The rule is that it all flows into one central pot, not into ministers' private accounts or departmental slush funds. Appropriation is the money going out, but only after Parliament passes a law saying exactly what may be spent and on what. That law is the budget made binding. The discipline is simple and strict: no appropriation, no spending. Money cannot simply leave the pot because an official wills it. This is just the household rule written in legal language: pool all the income, then require approval for every outflow. Once you see revenue in and appropriation out as the two halves of the same machine, the constitutional articles we'll reach in a moment will read like plain common sense rather than dense text. It's tempting to file public finance under economics, budgets, deficits, growth rates, and to think the constitutional lawyer has nothing to add. That is a mistake, and seeing why is worth a mark. Economics asks whether a particular spend is efficient, affordable, or wise. Constitutional law asks a prior and deeper question: who is allowed to make the decision in the first place? Because control of money is control of every other power the state has, you cannot run an army, staff a court, or fight an election without it. So deciding who controls the money is really deciding who holds power, full stop. That is why every serious constitution devotes whole chapters to finance, and why a question about the state revenue fund is never really about accountancy. It is about the location of sovereign power. Treat public finance as constitutional terrain, not bookkeeping, and you are already thinking like the examiner. Here is where it gets serious. Ordinary spending is visible, it appears in this year's budget, debated in the open, and people can see roughly where the money went. Debt is the quiet danger. A loan is spending the future's money today, you get the cash now, and the obligation to repay outlasts the very government that signed it. Worse, borrowing can be hidden, routed through a state-owned company, kept off the national budget, invisible until the bill suddenly arrives years later. So debt needs at least the same control as ordinary spending, and arguably more, yet it is far harder to police, precisely because it can be disguised. This is why a modern public finance question is rarely really about a budget line. It is about borrowing. Hold that thought tightly, because it sets up both our headline case and the critical paragraph that wins the marks. Now lift it from finance up to constitutional principle, because this is exactly what earns the marks. Debt is a democracy problem. When a government borrows today, the loan is repaid over years, sometimes decades. The people who will actually repay it, tomorrow's taxpayers, today's children, citizens not yet born, never voted for it. They are bound by a decision in which they had no say whatsoever. And democracy rests on a single foundational idea, that the people consent, through their elected representatives, to how they are governed and how they are taxed. So if borrowing escapes Parliament, it escapes the people altogether. That is taxation and debt without consent, the very grievance that constitutions were historically built to prevent, the cry that no taxation without representation was answering. Now you understand why parliamentary authorization of borrowing is not a dry technicality. It is democracy itself, defended at the level of the bank account. Let's root that idea in real law. Our anchoring case comes from right next door, Mozambique's hidden debt scandal, and you should be able to state the facts, not just name it. In the mid-2010s, a cluster of newly created state-owned enterprises took out enormous loans from international banks, money supposedly for things like a tuna fishing fleet and maritime security. The loans were backed by secret state guarantees, signed by officials in the government's name. The total ran into billions of US dollars. And the whole arrangement was kept off the national budget and away from Parliament entirely, hidden from the very citizens who would ultimately have to repay it through their taxes. When the scale of the concealed borrowing finally came to light, it triggered a financial and constitutional crisis. This is the exact danger from our last two scenes made horribly real: debt buried inside state-owned companies, escaping Parliament, escaping the people. Now watch what the court did about it. Now the holding, and it is striking. The matter reached the Constitutional Council of Mozambique, the body charged with guarding the Constitution, through public interest litigation. And the council did something bold: it found the loans and the state guarantees unconstitutional and invalidated them, because the debt had been incurred without the parliamentary approval the Constitution required. Read that as a principle, not merely a result. State borrowing carried out in the people's name, but without the people's representatives ever authorizing it, was treated as legally void, null, of no force. The remedy was not a polite recommendation or a slap on the wrist, it was to strip the unauthorized debt of its legal validity altogether. Parliamentary approval, the Council in effect held, is not optional decoration on sovereign borrowing, it is a condition of the borrowing being valid at all. That is a court enforcing the power of the purse with real teeth. Let's distill the principle, because this is the sentence you carry into the exam. Sovereign debt is incurred in the name of the people, they are the ones who ultimately repay it. It follows, as night follows day, that the people's elected representatives must authorize it, otherwise the borrowing has no democratic legitimacy at all. Unauthorized borrowing severs the loan from the only thing that could justify it, the people's consent, given through Parliament. And the Mozambican court's answer to that severance was uncompromising: no consent, no valid debt. Authorization is constitutive, not cosmetic. It is part of what makes the debt lawful in the first place, not a rubber stamp applied afterwards. This is the constitutional kernel beneath the headlines: borrowing in the people's name needs the people's representatives. Say that sentence in your answer and you have stated the principle the whole case stands for. Why does a Mozambican case belong in a Namibian answer? 3 reasons, and they are powerful. First, sovereign debt is the sharpest possible test of the idea that finance is really about democracy. It binds the very people who never voted for it, so a failure of control here is a failure of democracy at its most consequential. Second, the case shows the precise mechanism of failure: debt hidden inside state-owned enterprises, sitting outside the national budget and outside Parliament, until it detonates. Third, and most importantly for you, Namibia runs a large stable of state-owned enterprises and inherits a Westminster oversight model, which means the exact vulnerability that swallowed Mozambique exists here too. This is persuasive comparative authority from the region, not distant foreign theory. Mozambique is your warning case. Deploy it to prove that the gap between overseeing borrowing and authorizing it is real, regional, and recent, not some hypothetical a textbook invented. We've understood the idea and seen its failure in Mozambique. Now we make it precise in the Namibian constitution, and you will recognize every piece because it is the household analogy turned into binding text. There are really 3 things to root. First, Article 126 subsection 2, how spending is authorized, through appropriation acts passed by the National Assembly. Second, Article 125 and the State Revenue Fund, the single central pot into which all government income flows. Third, the keystone clause inside it, Article 125 subsection 4, that no money may be withdrawn from that fund except in accordance with an Act of Parliament. Underpinning all of it is the principle that the power to provide for revenue and taxation, and to release money, belongs to Parliament's legislation alone. Let's take each one slowly, because the exact wording is where the marks live. Start with Article 125, which creates the State Revenue Fund, and notice it is the revenue in half of our analogy turned into law. Sub-Article 2 is the key opening move: all income accruing to central government is deposited in the State Revenue Fund, and the authority to dispose of that money vests in the government. Read carefully what that achieves. By forcing all central government income into one constitutionally named pot, it guarantees there is no shadow stream of money flowing somewhere off to the side, outside the system. Every cent that comes in is supposed to land in the same visible place. The executive, the government, is given authority to manage and dispose of what sits in the fund, but, crucially, that authority is not a blank check, as the very next clause makes brutally clear. So Article 125 subsection 2 is the pooling rule: one fund, one pot, all the income in plain sight. That is the precondition for everything that follows. Now the keystone of the entire lecture, Article 125 subsection 4. No money shall be withdrawn from the State Revenue Fund except in accordance with an Act of Parliament. Read that slowly, and weigh every word. Not a regulation, not a ministerial directive, not a cabinet decision, an Act of Parliament, the highest ordinary form of law, made by the elected representatives of the people. So the executive may hold the money and manage the fund under Article 125 subsection 2, but it cannot take a single cent out of it except as Parliament's own legislation allows. That is the power of the purse compressed into one sentence and written into the supreme law. It is the legal expression of the family rule that the earner cannot spend the savings without the family's say-so. Memorize Article 125 subsection 4 word perfect. It is the spine of every public finance answer you will ever write, and quoting it precisely instantly signals command to the examiner. Pause on a question the exam loves to probe: why must it be an Act of Parliament specifically? Why not let the Minister of Finance release money by regulation, which would be quicker and simpler? Here is the answer, and it goes to the heart of the topic. A regulation or a ministerial order is the executive acting on its own authority. If the executive could release its own money by its own order, the spender would be approving the spend, and the entire separation we built would collapse back into one pair of hands, which is precisely what the Constitution set out to prevent. An Act of Parliament is different in kind. It is debated, amended, and passed by the elected House, so it carries the democratic consent of the people. That consent is the magic ingredient. Only an act carries it, so only an act can lawfully open the state revenue fund. The form is not bureaucratic fussiness, the form is where the democracy lives. If Article 125 is revenue in, Article 126 is appropriation out, and here is the move most students miss. Article 126 subsection 2, the National Assembly passes appropriation acts pursuant to the budget estimates. Look closely at what estimates means. The budget the Minister of Finance reads out with such ceremony is, at that moment, only a set of estimates, a proposal, a wish list, carrying no spending authority of its own. It does not become binding law until the National Assembly enacts it as an appropriation act. So Article 125 subsection 4 and Article 126 subsection 2 lock together like two halves of a lock, no withdrawal except by an Act of Parliament, and the act that authorises ordinary government spending is the Appropriation Act passed by the elected National Assembly pursuant to the estimates. Executive proposes, the People's House enacts. Cite them as a pair, 125, for the rule, 126, 2, for the mechanism, and you have shown the examiner you understand the architecture, not just the labels. Let's slow down on the journey from estimates to law, because it is where the democracy actually happens and students rush past it. Step 1. The Minister of Finance tables the budget, the estimates. This is the executive's proposed plan for the year, and it is important to see that at this stage it binds no one. It is a request placed before the People's House, not a command issued by the executive. Step 2. The National Assembly takes that proposal and does real work on it. Members debate it, they may amend it, they scrutinize where the money is going, and then they vote. Step 3. If it passes, it becomes an appropriation act, and only at that moment does any spending authority come into existence. So the vote in the chamber is not a formality tacked onto a done deal, it is the precise moment at which the people, through their representatives, consent to the year's spending. That is why the Appropriation Act, and not the minister's speech, is the source of the power to spend. Let's complete the circuit, because the consent principle guards both ends of the pipe, not just the spending end. We've focused on money going out, but watch the money coming in. The power to impose taxation, to reach into citizens' pockets and take their money, also belongs to Parliament. Taxes may only be levied by or under an Act of Parliament. That is the ancient principle of no taxation without representation, and it sits at the very origin of constitutional government. So put the two ends together. On the way in, Parliament must consent to the tax that fills the fund. On the way out, Parliament must consent, under Article 125 subsection 4, to every withdrawal from it. The executive administers the whole system day to day, it collects, it manages, it spends, but it cannot open either valve, intake or outflow, on its own authority. Both valves are wired to the people's consent. See finance as that closed circuit, gated at both ends by Parliament, and the structure is complete. Before we turn to the audit half, we need to see exactly how borrowing slips the net, because this is the mechanism behind Mozambique and the heart of the critical debate. The trick is rarely a straightforward government loan, which would at least show up in the books. It is the state guarantee. Instead of borrowing directly, the state stands behind a loan taken by a state-owned enterprise. It guarantees the debt. Watch what that does to our controls. No money leaves the state revenue fund today, so the guarantee never triggers an appropriation act and never appears as ordinary spending, yet the state is fully on the hook. Lawyers call this a contingent liability, a debt that only crystallizes if the enterprise defaults, at which point the guarantee is called and the taxpayer must pay. So the very front-end control we admired, no withdrawal without an Act of Parliament, simply does not bite on a guarantee, because nothing is being withdrawn yet. That is how billions of real future debt can be incurred entirely outside the budget. Remember this mechanism, it is what makes oversight, not authorisation, so dangerous a default. We have built the first safeguard in full, authorisation before the money moves. But remember the household, approval beforehand is only half the discipline. The other half is the honest check afterwards, someone other than the spender sitting down with the bank statement to confirm the money actually went where it was supposed to go. A constitution that only authorized spending, but never checked it, would be trusting officials never to lie, never to misdirect, never to steal. So Namibia builds the after-the-fact check into permanent institutions. Two names matter above all. The Auditor-General, the independent examiner of the public accounts. And the Public Accounts Committee, the PAC, the parliamentary body that takes the auditor's findings and does something with them. Authorization before, audit after, that is the complete machine. Now let's root the audit half in the precise law, exactly as we rooted the authorization half. Start with the auditor. Article 127 subsection 2 provides that the Auditor-General tables the annual report in the National Assembly. Notice where the report goes, not to the President, not quietly into a ministry's drawer, but onto the floor of the elected House, in public, where representatives and ultimately the people can see it. That choice of destination is itself a constitutional safeguard. But a constitutional office needs real powers to be more than ceremonial, and those powers live in ordinary legislation. Part 3 of the State Finance Act of 1991 equips the Auditor-General with genuine investigation and auditing powers, the authority to examine accounts, demand documents and probe how public money was actually used. So the audit is not a polite annual letter, it has legal force behind it. Article 127 subsection 2 for the constitutional duty to report to Parliament, and the State Finance Act of 1991 for the investigative muscle, cite them together, and you've shown the auditor is a real watchdog, not a paper one. Now the body that gives the audit its bite, because tabling a report achieves nothing if no one ever reads it or acts on it. Enter the Standing Committee on Public Accounts, the PAC, governed by Rule 69 of the National Assembly Standing Orders. Under Rule 69 the PAC examines the appropriation accounts, checking that the money authorized by those appropriation acts was actually spent on what Parliament said, and it examines the Auditor-General's reports, makes recommendations, and, crucially, follows them up. That follow-up function is what stops the whole exercise from being theatre. The PAC is, in effect, the family member from our analogy who sits down with the bank statement and asks hard questions about every line that looks wrong. It closes the loop that began with the Appropriation Act. Parliament authorized the spend, the auditor checked it, and now the PAC interrogates the result and demands answers. Rule 69 is the engine of accountability after the fact, name it precisely. The PAC does not float free, it sits inside the National Assembly's wider committee architecture, and showing you understand that structure lifts an answer. Under Rule 54, the PAC is constituted as a portfolio committee, one of the standing committees through which the National Assembly does its detailed work. This gives it a permanent place in the institutional furniture rather than an ad hoc existence. And Rule 64 sets out the general oversight function of National Assembly committees, the authority to hold what the standing orders describe as investigative and oversight hearings. That phrase matters, it means committees, the PAC among them, can summon, question, and probe, not merely receive paperwork. So layer the rules together. Rule 69 gives the PAC its specific mandate over the accounts and the auditor's reports. Rule 54 places it in the committee system as a portfolio committee. Rule 64 supplies the general investigative and oversight hearing power it draws on. Cite all three and you have mapped the oversight machinery with real precision. There is one more strand to the accountability web, and it shows the duty to account is not confined to the auditor and the PAC. It is woven into the relationship between the executive and the legislature at the constitutional level. Articles 32 and 40 carry duties of reporting on the previous year, obligations on the executive arm to render an account of what was done and how the country was administered in the period just past. The detail of who reports what matters less, for your purposes, than the pattern. The Constitution deliberately builds in moments where those who exercised power must turn around and explain themselves to the people's representatives. Add this to the picture and accountability becomes a layered system, not a single checkpoint. The auditor examines, the PAC interrogates, and Articles 32 and 40 require the executive itself to report back on the year gone by. Each layer catches what another might miss. The point to take into the exam, accountability in Namibia is plural and structural, not a single lonely watchdog. Now the structural point that becomes your critical paragraph, and you must see the asymmetry clearly. Look at how spending and borrowing are treated, side by side. Spending is authorized in advance, nothing leaves the State Revenue Fund without an Appropriation Act passed first. That control is strong precisely because it is prior, Parliament says yes before the money goes out. But borrowing is treated quite differently. Namibia inherits a Westminster system, and the Westminster instinct is to focus on the oversight of borrowing rather than its prior authorization. In practice, that means Parliament tends to scrutinize debt after the fact, through the Auditor-General and the PAC, rather than approving each individual loan before it is signed. There is a phrase that captures the consequence exactly: the exercise of the budget function depends on the efficient exercise of the oversight function. In plain terms, if the after-the-fact check is weak or slow, control over borrowing is weak. That is the gap, and it is precisely the gap that swallowed Mozambique. Now the critical debate, the part that separates a pass from a distinction, and here you must be honest rather than flattering. Is Parliament's oversight of public debt a real control, or is it closer to a rubber stamp? Make the skeptical case properly. After-the-fact oversight is, by its nature, slow and backward-looking. By the time the Auditor-General has audited the year, tabled the report, and the PAC has met to examine it, the loans are long since signed and the money long since spent. The watchdog arrives after the burglary. Worse, the oversight bodies are staffed from the same Parliament the executive often dominates. A strong governing majority can blunt committee scrutiny from the inside, declining to chase the awkward question. So the honest question is sharp: does Parliament genuinely control borrowing, or does it merely audit the damage once it is done? Posing that question fearlessly, rather than reciting a tidy list of safeguards, is exactly the move the examiner is waiting for. Drive the lesson home by applying Mozambique directly to Namibia, because abstract worry is weaker than a concrete regional warning. Mozambique was not a country without oversight institutions. It had its auditors and its committees, just as Namibia does. What it lacked was prior authorization of borrowing. Nobody had to say yes before the state-backed loans were signed. And so billions in hidden debt, buried inside state-owned enterprises, slipped clean past the whole oversight apparatus until the damage was catastrophic and irreversible. Now hold Namibia up against that. Namibia shares the very same structural features: a large portfolio of state-owned enterprises, and a Westminster model that polices borrowing after the fact rather than before it. The gap that swallowed Mozambique is, structurally, open here too. That is why this case is not a piece of foreign color you sprinkle in for decoration. It is a live, regional, recent warning about a vulnerability in Namibia's own design. Use it as the evidence that your critical worry is real. Sharpen the critique 1 degree further, because this is where a truly strong answer pulls ahead. Even taking the PAC at its best, notice the limit baked into its very design. Under Rule 69 it examines the accounts and the auditor's reports, criticizes, and recommends, but it cannot itself punish a wrongdo, recover a stolen cent, or force a department to change. Its power ends at the recommendation. And who must act on those recommendations? Largely the executive and the prosecuting authorities, the very arms the PAC exists to check. There is a circularity there worth naming. Add the practical frailties. Audit reports can be tabled late, sometimes years behind. Findings can sit on the table unactioned from one session to the next. A committee dominated by the governing party may decline to chase its own side too hard. So oversight without enforcement is only half a check. A diligent PAC can expose exactly what went wrong and still watch nothing happen. That is the honest, sophisticated edge to bring to the borrowing debate, and it is precisely why prior authorization matters more than after-the-fact audit alone. An examiner rewards a defended stance, not a fence-sitting tour of everyone's views, so take one, and take it with nuance. Here is a defensible position you can adopt. Begin by conceding the genuine strength. On the spending side, Namibia's controls are real and strong. Article 125 subsection 4 and Article 126 subsection 2 mean nothing leaves the fund without prior parliamentary authorization, and that is exactly as it should be. But then press the weakness without flinching. On the borrowing side, the after-the-fact Westminster oversight is structurally insufficient, because, as Mozambique shows, by the time the audit lands the harm is already done. So the position is this: genuine democratic control of public debt requires prior parliamentary authorization of major loans, not merely retrospective audit. Borrowing should be gated at the front end, just as spending is. And frame it as reform, not despair. Keep the Auditor-General and the PAC, which do valuable work, but add a front-end approval gate for significant borrowing. Concede, critique, propose. That balanced, reasoned stance is what a distinction answer looks like. Part 6, turning all of this into marks, starting with decoding the question. The standard form is something like, critically discuss the constitutional control of public finance in Namibia. Read the verb. Critically is an instruction, not a decoration. It means do not merely describe Articles 125, 126 and 127, weigh prior authorization against after-the-fact oversight, expose the borrowing gap, and take a defended side. Students who only describe the articles are capped low no matter how much text they reproduce. Then watch especially for the borrowing angle. A question phrased as, how effectively can Parliament control public debt, is steering you straight to the Westminster gap and Mozambique. And recognize the re-angled variance, the power of the purse, parliamentary control of the budget, accountability for public money. They look different but want the identical engine, just entered through a different door. Whatever the wording, your machine is the same: power of the purse, the articles, the accountability machinery, the critical gap, a position. Train yourself to see that engine under any phrasing. Now the architecture, 5 moves you run every single time, the same skeleton you've used for every constitutional topic. Move 1, thesis, state up front that public finance is a system of democratic control over money, not mere bookkeeping. Move 2, establish the doctrine, Article 125 and the State Revenue Fund, the keystone Article 125 subsection 4, Article 126 subsection 2 and Appropriation Acts, then the Mozambique hidden debt case showing what happens when borrowing escapes Parliament. Move 3, apply the accountability machinery, Article 127 subsection 2 and the Auditor-General, the State Finance Act of 1991, the PAC under Rules 69, 54 and 64, and the reporting duties in Articles 32 and 40. Move 4, the one most students skip and the single biggest differentiator, the critical paragraph, expose the Westminster oversight not authorization gap and ask whether Parliament can really control borrowing. Move 5, a reasoned position that ties it together and defends your thesis. Skip move 4 and you are capped around 65% no matter how much you've memorized. Include it, properly argued, and you are competing for a distinction. Let me show you what that critical paragraph actually sounds like on the page, because seeing the real sentences is worth more than any abstract advice. You might open like this: the decisive weakness in Namibia's public finance framework lies not in the control of spending, which is tight, but in the control of borrowing. Then state the gap: spending may not occur without prior parliamentary authorization under Article 125 subsection 4 and Article 126 subsection 2, yet borrowing, in this Westminster-derived model, is largely only overseen after the fact, through the Auditor-General under Article 127 subsection 2 and the Public Accounts Committee under Rule 69, so the budget function depends on a necessarily slow oversight function. Then the evidence: the danger is not hypothetical. In Mozambique's hidden debt scandal, state-owned enterprises borrowed billions off budget without parliamentary approval, and the Constitutional Council ultimately invalidated those loans. Then land it in Namibia, as Namibia shares both the proliferation of state-owned enterprises and the after-the-fact oversight model. Genuine democratic control of public debt requires prior parliamentary authorization of major loans, not merely retrospective audit. That is the rhythm, claim, gap, evidence, Namibian payoff. Copy that shape. Before the recap, the things that quietly kill marks, and how to spend your time. Mark killer number 1, describing Articles 125, 126 and 127 beautifully but never taking a position on whether Parliament can really control borrowing. Examiners reward a defended stance, not a recitation. Number 2, vague citation. Writing the Constitution says money needs approval is worth almost nothing. Writing Article 125 subsection 4, no money shall be withdrawn from the State Revenue Fund except in accordance with an Act of Parliament is worth real marks. Precision is the currency. Number 3, omitting the critical paragraph and the Mozambique case, which together cap you around 65 however much else you know. Now the time budget for, say, a 45-minute essay, about 5 minutes planning the 5 moves, then 35 writing, roughly 3 minutes on the thesis, 10 establishing the doctrine, 10 applying the accountability machinery, 8 on the critical paragraph, 4 on the position, and keep 5 minutes at the end to check you actually took a side and cited Mozambique and the precise articles. Plan, write to the budget, defend a position. Do that and the marks look after themselves. We've covered a great deal, so let's lock it in over 2 recap scenes. First, the spine of the whole topic. The power of the purse means whoever controls the money controls power, so the Constitution makes Parliament, not the President alone, authorize both spending and borrowing. Remember that public finance is a constitutional question and not merely an economic one, because deciding who controls the money is deciding who holds power itself. The structure is revenue in, then appropriation out, pool all the income into one pot, then require an Act of Parliament for every outflow. And debt is a democracy problem, because today's borrowing binds tomorrow's citizens who never consented to it. Underpinning the whole machine is the household rule in 2 halves, authorization before the money moves, and an honest audit after. Hold the spine, now we lock down the precise authorities. Now the authorities, word perfect. Article 125 creates the State Revenue Fund, the single pot for all central government income, and the keystone, Article 125 subsection 4, provides that no money may be withdrawn except in accordance with an Act of Parliament. Article 126 subsection 2 makes that concrete. The National Assembly passes appropriation acts pursuant to the budget estimates. On accountability, the Auditor-General tables the annual report under Article 127 subsection 2. Backed by the investigation and auditing powers in Part 3 of the State Finance Act of 1991, the Public Accounts Committee examines the accounts and the auditor's reports under Rule 69, sitting as a portfolio committee under Rule 54 and exercising the oversight hearing power in Rule 64, and Articles 32 and 40 add the executive's reporting on the year past. Your mark-winning critical move is the Westminster gap. Borrowing is overseen, not authorized, with Mozambique's invalidated hidden debt loans as the warning. And the answer always runs, thesis, establish, apply, the critical paragraph, then a reasoned position arguing for prior authorization of major loans. Understand it, root it, deploy it. In the next lecture we turn to judicial independence, the guardian that protects every safeguard we have built today. I'll see you there.